Well, today we're discussing a bit of a heavy topic, sexual assault lawsuits that lawyers take on, and you would be surprised how many of them there are. Howard Yegendorf is an Ottawa personal injuries lawyer. When we say we'd be surprised, are there a surprisingly high number of those lawsuits out there?
They are quite prevalent, Michael. When I started practicing law, I was kind of surprised to see how many people grew up with that kind of abuse in their home. It's a little disheartening to see, but it is prevalent. And luckily, in a sense, the discussion, the societal discussion, is more positive now. It's not stigmatized the way it used to be. There's more of a discussion about it today than there was 20, 30 years ago, for sure.
Now, you are a personal injuries lawyer. When you think of sexual assault case, you think of criminal cases where you have to go to the police, somebody's charged, you go to court. Your role in this would be a little different.
Well, yes, a person can lay a complaint to the police of a sexual assault, and there would be criminal charges if the police felt that it was merited. A person could also sue the perpetrator for a civil action of sexual assault.
And would the civil action come after a criminal case if in fact there was one?
It could be contemporaneous, it could come after.
Oh, okay.
Oftentimes people don't bring criminal charges at all. The sexual abuse could have happened literally decades ago when the person, now an adult, was then a child. And they don't bring criminal charges, they bring simply a civil action.
You mentioned the stigma not attached to it anymore. And I think that's such a big part of this because there is such a stigma attached to it. Why has it changed?
Well, I think that the public, so much of it has happened. It's come out of the woodwork so much. And, in the old days, I had clients who were telling me that, when they were a kid, if they told their mother that somebody of a religious nature sexually abused them, the mother would say, don't say that, don't talk about that person in that way. People are more open about that today. And the government has taken the lead also in recognizing the fact that these are prevalent, these are very real cases, and people are significantly damaged by these events. As an example, the Ontario government, some time ago, amended the Limitations Act. Very favorable treatment to victims of sexual abuse. So for example, if I sue you for a car accident or a breach of contract case, I have to bring my action within 2 years of the incident occurring. But with respect to sexual assault, there's no limitation period in most cases. And the government has recognized that people have great difficulty in bringing these claims. Oftentimes, for years, people blame themselves. And the government recognized that in the amendment to the Limitations Act by saying, we know that these people take sometimes decades to get to the point where they can find it within themselves to recognize that they've got a civil claim against somebody. So those claims are no longer statute barred, particularly if the abuse occurred in the context of a relationship of trust or authority.
Teacher or priest?
Yeah, very notorious case was the Graham James case.
Yes.
It was a coach of a junior A hockey team who abused some of his players, most notably Fleury and Kennedy. And so he was in both a situation of trust and authority. You can imagine the type of leverage he could have placed on his players.
This is one of these stories we could spend a whole show on.
Sure.
Howard Yegendorf, Ottawa personal injuries lawyer. Always good to talk to you. Great information out there today. Thank you, Howard.
Thank you, Michael.